Katrina Shanks.
It's my pleasure to take a short call on this bill tonight. It's an honour and a privilege to be speaking on such an important topic at the first reading of the Habeas Corpus Amendment Bill. Obviously, my colleagues are very well read on Latin, and I cannot compete in any way whatsoever, apart from to say et aspera per aspera, which are the 4 words that I know, which is to the stars for endeavour, which was my school motto. So that's as good as I get, I've got to say. What does it mean? To the stars through endeavour, very important. It's a girl's skill for you. It does indeed. So I'd just like to acknowledge my colleague, Chris Arkenvold, for the work that he's put into getting this bill to the ballot and drawn to its first reading today. And also I'd like to acknowledge the Law Commission for the work that it's put into its early stages to get the bill to the House today. And also the Justice and Electoral Committee, which is led by the fabulous Tim McIndoe and Deputy Chair of Cam Calder, and the work that they're going to do when it gets to the Select Committee, of course. And obviously it'll be a quick turnaround for this bill to get it back to the House for the second reading. So, the Habeas Corpus is a pillar of the criminal justice system. It safeguards the liberty of New Zealand citizens. This is an application under the 2001 Act, which allows the validity of any arrest or detention to be tested. If it is found to be unlawful, the court may issue an order and that person be released. This reflects one of the most important ideas in a free and democratic society, that there is a general right to liberty unless there is a legal basis for that liberty to be removed. This idea is so important that it is enshrined in our Bill of Rights. Mr. Speaker, in recognition of the importance of this bill helps us to recognise and modernise the process under which the courts examine the wrongful detention of applications. These changes prevent the erosion of the process through misuse and allow for technological advancements to be incorporated, facilitating the progression of applications through the courts. This bill does come in light of the Law Commission's report and the anomalies, how this original Act has been applied. And I know previous colleagues in the House have spoke to that in detail, so I don't need to speak to that. Obviously, the history of this is long and varied and has come way back from the 14th century. So it has a long history in our court judicial system through New Zealand and United Kingdom as well. So with its enactment, there was the requirement that the applications have precedence over all other court business. And this was a reflection of its absolute importance. However, some applications, including prisoners serving sentences, have been applying this inappropriately. And because of that, this bill has come about to ensure that the courts have a bit more flexibility and allows for the justices of the High Court the freedom to dispense with the rule that the applications takes precedent in cases where the system is being abused. So it provides them with the flexibility and keeps our courts more modern. It also has allowed them to use more technology, but more technology in a safe way, ensuring that every application is inspected by a High Court judge as it should be. This bill allows for teleconferences, for audio-visual links, and it also will allow for a number of applications to be disposed of in a very timely manner. This is a government whose priorities is about better public services. This is just one more example of that to ensure we have an efficient and effective management justice system. Mr. Speaker, I commend this bill to the House. Thank you.
Dr. Kennedy Graham.